Hello guys, this is Aramandas Sharma and we are going to go through the basics of contract law. Once again, I would like to thank Law Issues Committee for giving me the opportunity to present on this topic. So, contract, the thing that governs our entire life today, from watching videos on YouTube to buying something online to literally going physically to buy some groceries. A contract is involved. What is a contract? A contract is an agreement enforceable by law. Section 2H clearly states that a contract is an agreement enforceable by law. Section 2H of Indian Contract Act. Oh, before that, Indian Contract Act is the governing principles and set of rules that is governing and giving a structure to valid contracts in India. Indian Contract Act 1972. So, back to the topic. 2H of Indian Contract Act 1872. Indian Contract Act 1872 says a contract is an agreement enforceable by law formed between two or more parties. It is a result in obligation that are legally binding. Again, it should be between two or more parties. A contract could not be within oneself. It should be legal agreement. It should contain legal terms that are permittable under law and should not be voidable. It cannot be voidable. It cannot be void. What is void? Void is void ab initio, void from the beginning. That is non-existent from the beginning. And voidable means it could be non-existent and it could be existent. It could exist depending on the contract itself. Mutual consent. As mentioned in the definition, a contract is an agreement. Agreement comes in the mutual consent. How this mutual consent is formed? When party A agrees to do something for party B and party B agrees to do something in exchange for in exchange to party A's offer is a mutual consent is establishing a mutual consent between them and forming an agreement. And again, one part that I forgot, this agreement in itself cannot be a contract. Again, a party agreeing and making an agreement itself cannot be a contract. It should have a legal liability. It should have a legality. It should be enforceable by law. Both the parties should say, yeah, I agree that you can sue me on the basis of this. And the law should consider it as a contract, mutual consent. Now, let's go on more further. What are essentials of a valid contract? An offer must be clear and definite. An offer must be made by one party to another. Acceptance of an offer must be unequivocal and communicated to the offerer. Offer should be clearly communicated. According to Section 2A, when one party signifies to another party his willingness to do something or abstain from doing anything with a view to obtaining the assent of the other party to such act or abstinence, he is said to make a proposal. Simpler, in simpler terms, A party goes to B and offers him, hey, I'm going to sell you this back on discount for only 40 rupees. That is an offer. Acceptance, and acceptance of an offer must be equivocal and communicated to the offerer. When party B again the example to make it simpler, party B to whom the contract is communicated says, okay, I'm going to accept it. The communication is important key here. The communication of the contract is done, then that is a valid acceptance. Offer plus acceptance plus consideration. Come to consideration. There must be something of value in exchange. You both should give something to each other. If you're not giving to each other, it could be considered a gift. If you're just giving him it for free, then how it is different from charity or a gift. Both the parties should have some value to each other. For example, in this example of a bag that I gave, party A is receiving the money and party B is receiving the bag. Both have something of value. Again, that is an agreement. Offer plus acceptance plus consideration plus legal validity. The The contract should be legally valid, enforceable by law. Example, the contract in itself is valid. Example, buying and selling of a bag is not illegal, but exporting illegal stuff from other countries and banned items from other countries and selling it is illegal. So, or any agreement on it, it cannot be a any agreement on the illegal consideration cannot be called a contract. And again, to make it legal, there should be a capacity to contract. Again, the parties must have legal capacity to enter into a contract. The parties who are getting into a contract should be of a major, should be not a minor, should be of a sane mind, and should not be disqualified by law. Again, law plays such an important factor here. If it is illegal, then the whole contract goes into the stage of void. Offer and its essential. Definition of offer. An offer is a proposal made by one party to another indicating the willingness to enter into a contract. Communication of offer. देखो तुमने offer, you know, see, you know what is an offer. Now, this offer should be communicated. You cannot make an offer on yourself and later on go and sue that person saying, I made an offer. He did the thing. Now, but he did not do the thing according to me. What offer? You have to communicate it. It must be communicated to the offeree for it to be valid. An uncommunicated offer has no legal effect. This. Now, next point. Intention to create legal relation. Again and again, one point is coming up. Legal relation. It should have a legal liability. The offer should indicate an intention to create legal relationship, distinguishing it from mere social agreement. It could be a social agreement, but it won't have a legal validity. You cannot sue it. Example, I say, oh, you are my best friend. I'm going to cover everything for you. Later on, I do not even pay a single penny to support you in hospital. You cannot sue me. Yeah, I know it's a cruel world, but you cannot sue me because it does not have a legal relation. Again, whatever law says is the law of the land. Whatever sovereign says, again, sovereign means the authority governing the place, is the law of the land. So, legal relationship is important. Certainty. The offer must be clear and certain, allowing offeree to understand what is being proposed. Consist is that item again. If you are not clear and there's a discrepancies, many times it happens in contract. And many times, due to that reason, the contract has failed because both the offeree was not clear enough. If I say ball, I have to be very specific and clear. What type of ball? Titanium ball, plastic ball, water balloon ball, uh, ball made of feathers. Which ball? So certainty is must. Acceptance of offer. Definition of acceptance. As we said, as we read, acceptance is the expression of assent of terms of offer forming a binding contract. Again, it's an expression. I say, yes, I agree. I agree. So, that is an acceptance. Mode of acceptance. Acceptance can be expressed verbally, in writing, or implied. Again, these three terms. Verbally, I say that I accept. And in written, I write my, like put a signature to a thing. I agree. So this thing can be verbal, could be written, and could be implied. How implied? Wait, what do we mean by implied? Implied means is already there by your act. Implied means by your conduct. Implied means by your conduct. Now, how by your conduct? Example, you go on a bus. It's an implied contract that if you step on a bus, you have to pay or you're gonna get kicked out. That's an acceptance. Time frame. Acceptance must occur within the time space specified in the offer. Time frame specified within the contract. Time frame specified within the contract within reasonable time and revocation of the offer. Now, time frame. Come to the time frame part. You cannot go and ask a person after 2 years of a contract. Again, if it is not explicitly mentioned, example to clear things off. If a person gives me, hey, I am offering you these bananas for free if you buy this apple, you go after 1 year to the same stall saying, hey, I have an agreement, I'm going to sue you. You cannot do that. It's not reasonable. And the time specified in the offer is not there. Revocation of the offer. An offer can be revoked before acceptance, but not after. Again, I repeat, a, a offer can be revoked before acceptance, but not after. So that means clearly, that means clearly that there could be revocation. According to section 6, it clearly says you can revoke an offer. Sorry, you can revoke an acceptance, not offer. Section 6 says you can revoke an acceptance. Sorry, you can revoke an acceptance. But here we are talking about offer. So you can revoke an offer too. But if you are saying I accept after the offer is gone, you cannot you cannot expect to actually receive the service or the benefits you agreed upon because the time is gone. Invitation to offer. What is an invitation to offer? Simple. An invitation to offer signals willingness to negotiate terms. It is not an offer in itself. Example, I put a stall of different option with price tags on it, but I did not offer it to you. You look at a thing, you see this is the offer that you're available in dining, in a restaurant. When you enter and you look at a menu, that's an invitation to offer. When you select something and order something, or the other person actually comes to you, then the offer is made and the acceptance is also made simultaneously. Example, advertisement, catalogs, price lists, inviting public to make offer, distinction from offer. Differentiating between the offer and offer is essential for building contract. Offer is something that is explicitly mentioned to you. Invitation to offer is, hey, I can offer you this. You can see that person is clearly making a point that he can offer. He's not offering. And legal interpretation, legal implication does not create a legal obligation. It invites a proposal that may lead to a that may lead. Conclusion. And before conclusion, one of the most famous case laws I want to talk about, Carlin versus Carbolic. In this, there was a company. Again, let me repeat the name, Carlin versus Carbolic Spoke Ball Company. In this, there was a company which was claiming, hey, I can make a smoke ball that can cure pneumonia or some kind of disease. And if not, see, I have this amount of money here in my bank, an official statement saying that they have this much and proving them that they are gonna refund you in case it doesn't work. A woman with all hopes buys it. Sadly, it doesn't work, and later she sues them. But what the Carlin Smoke Ball Company excuses or defenses? Hey, this was just an advertisement. But the judge, but the lords at the house claimed no. You prove that you are gonna pay them. You literally give every reason for a reasonable person to think and believe in you. Even showing your bank statement and claiming and showing this much amount in your bank, you are legally liable because you made an competent offer. And here also comes the implied part. Remember, I told you three types of acceptance can be there: written, verbal, and implied. Implied in the sense, in Khalid versus Smoke Ball Company, when you send and When you send an advertisement claiming an offer saying that we are going to do this if you buy this, the acceptance is implied. The acceptance is implied. It's not because you said an offer to them saying it's an only an advertisement. We didn't offer to them only. No, the acceptance is implied because you said, and the other person agreed to the terms legally and lawfully. Then you're legally binding. This is an implied contract, as the example I gave you of a bus. Summary. These essentials are valid of a valid contract includes clear offer, acceptance, consideration, and legal capacity. A person, according to the Majority Act, has to be over the age of 18 to be called an adult and make informed decision. So, making a valid contract and should be of a sane mind and should not be disqualified by law. Again, law plays a very big role here. Importance of clarity. A clarity in communication between party enhances the chances of successful contract relationship. A contractual relationship, to establish a very powerful contractual relationship, to make a valid, to make it actually legally binding, you need to be clear. You need to be absolutely clear and not leave us and cannot leave a single point of ambiguity because it could lead to voidable or void contract. If you're stating you're going to sell desk, clear out what type of desk. Legal framework. Again, Indian Contract Act provides the necessary legal framework to ensure proper formation and enforcement. So thank you. This much. I hope you like the overall brief and basics of a contract. This was from my side, and hopefully you liked it. Thank you and have a nice day.